So this is Contracts Class 5. We'll do our usual brief administrivia, then I'll do a recap to warm up the circuits. I'll take any questions that you have. We've closed out now our first real unit. We'll then move into contract formation, what it takes to form a contract. So, first of all, administrivia. I don't have anything other than I did get a copy of the supplement in the mail, so they do exist. For those of you who are getting feedback from the publisher that somehow it's not available or whatever it is, if you're still having trouble, get with me and I will cause problems for them. They've already been told we are not using the supplement again next year. So that's one place to start. I think that's all the administrivia I've got, unless anybody else has got questions. Office hours, of course, are immediately after this class. Unless there's a large number of people, we'll go up to my office. That way, students in other classes and other years can come by as well. All right. So we've been doing in the first 2 weeks of class, what's a contract? And inherent in that question is, what's not a contract? So contract is the law of bargain for exchange. Contracts are bargain for exchanges for which the law offers a remedy. The problem is, then there are a few things that are close enough to contract that we might need to ask the question. I think we all understand a tort is not a contract, right? But there are some things that are close enough to contracts that they beg the question, things like promissory estoppel, where we enforce a promise to the tune of the out-of-pocket costs that the person who received the promise reasonably undertook in reliance on that promise. And also restitution, where somebody's been given something that it's unfair for them to keep, and therefore they have to give it back, and if they can't give it back, then they have to pay for it. But there's a wrinkle on the wrinkle, which is those doctrines, which look a lot like contract, are kind of like stunt doubles, right? So the problem with the stunt double is not only do you get pulled in for bad times in the movie, but you also can be mistaken for the actor themselves under certain circumstances. And so what happens is that these two doctrines get pulled back into contract law to patch up places where the contract doctrine has fallen down. And often, not always, but I'll go out on a limb and say more often than not, what's going on in these so-called quasi-contract doctrines of promissory estoppel and restitution is that they are not acting in their core, easy, obvious, black letter roles as non-contractual cases, that this is not a contract. But rather they are acting in cases in which the court thinks there should have been a contract, and there's some very specific black letter reason why the court can't say that. Now, TVA is just our most recent example of that, where the court is pretty pissed because there was a contract to create those microfiche films. It was signed. It was executed. The product was delivered, and then the government pulls this stunt where they're like, yeah, but sorry. It turns out that this guy just broke into our offices and was signing contracts, even though he had every appearance of being the appropriate person to sign the contract. How in the world would the service provider know, you might ask yourself? How would you know? You sign a contract with somebody to buy a building. How do you know that the person, the real estate agent, suddenly magically doesn't have the authority, right? That's nonsense. But the court's stuck because its interpretation of the relevant rule under those provisions can't let it get out. And so what the court does is, get this, finds a way of enforcing a restitution interest that looks exactly to the dollar like enforcement of that contract. And the way they did it teaches us a little bit about restitution. What they said was, you received a benefit in the form of the microfiches that it's unfair for you to retain. Turns out the microfiches were a terrible investment to start with, and so their response is, well, we'll give them back to you. And the guy's like, no, I don't want them back. Mind you, that would be if this were restitution, that would be largely what we would be looking at here. But it's not a real restitution case. And so then the court goes and has this long, dark night of the soul about which measure of restitution are we talking about. And there are two. within the restatement third, and this is one of the only places we will use a third source of law throughout this entire course, in the restatement third of restitution and unjust enrichment, right? There's a different restatement for restitution. It's a different deal. They said, well, there's two ways of looking at the value that needs to be returned, that it's unfair for the person who received the benefit to keep. The first way is to measure its value to the person, that is, its subjective value. Well, already that becomes a question then that TVA tried to muddy, right? So it said, well, they're not worth anything to us now because it turns out nobody was interested in the thing. But that's a lousy measure of the subjective measure of all of this. The better measure of the subjective value of TVA of the microfiche would be what? Benefit. What would be a better measure of the benefit? Fair market value? The cost to buy it from somewhere else. That's where I'm going in a minute. But I'm showing you on the subjective measure. What's the best measure of what it was actually worth to them? The pre-existing contract. What they offered to buy it when they had the chance to, right? That's what our best measure is. Similarly, the court notices then, fair market value, right? That's another measure. And I think fair market value is also a really solid move because that's commonly, we want to go sort of outside, we want to have an objective measure of the value of something. That's because of a problem that I mentioned in class. I called it drive-by contracting or drive-by conferring of a benefit. You can't use restitution, and you want to look it up, you can. It's called opportunistic restitution. You can't officiously, they also like this word officiously, you can't officiously confer a benefit. I can't mow your lawn at 3 a.m. and then expect payment, right? I can't force this thing on you. And the fair market value is a pretty nice constraint on that because we would say, well, what would a person within the market pay for this? And the answer is nobody would pay for their lawn being mowed at 3 a.m. without their consent. That's not a thing. So we've got our fair market value, which is what the measure of it is out on the market. But notice what the court does again, because it's a thin market. If it had been a thick market, if people had been buying these microfiches every day and twice on Wednesdays, then they would have had a good benchmark and maybe the court would pick that. But in this thin market, miraculously, the only evidence that they've got as to the market value of these microfiches is the other company that would have gone to, except the quote, yeah. The contract itself, right? In the thin market, again, they go back to this contract. So we've got this mixture between the two, this other quote, right? And then also the contract that they sign. And so in both cases, what the court does is it redirects the damages measure back to something that, if it isn't identical to the expectation measure of damages under this contract, I don't know what is. It is the expectation measure of damages, as if this were a breach of contract case. And TVA should really stand for that proposition throughout the course. Largely what these quasi-contract doctrines are doing in this course, sure, they're giving you another couple of bites at the apple. Count 1, breach of contract, and if your jurisdiction lets you, count 2, promissory estoppel, and count 3, restitution, if you want. But that's not really what they're doing most of the time. Really what they're doing most of the time is picking something that should have been a contract, but for some reason wasn't, and the court is wanting to get down on it, okay? Any questions on that or on anything else that we've done before we move into the cases? Yeah.
Question on that. So the book refers to contract in law versus contract in fact. So in this case specifically, this was a contract in fact because they had signed an agreement even though the TVA was saying that.
Yeah, there's a lot of confusing doctrine, and I hate the language of implied contract. There are certain places where the court will imply a contract as a matter of public policy, and the difficulty is that courts really have a hard time dealing with that. We're going to find a contract here because there's some public policy reason to not let people just walk away, versus the other kind of implied contract that they do all the time, which is what you did. Your actions implied the existence of a contract, right? So the one is, there's a contract here as a matter of public policy. The other is, no, like I get it, you didn't sign on the dotted line, but you did things that made us think there was a real contract here. You implied the existence of a contract. And so we get into the weeds somewhat on those doctrines. I will not be using implied in fact, implied in law here. I will say this, there clearly was a contract. Y'all see me? Now, that contract was not enforceable. Why? Why was the contract not enforceable in TVA? Yeah.
Lack of the formalization.
Lack of the formalization, but also was it and see, this is where we get tied up because it was a signing problem, right? That leans towards formalization. But Leland,
There was a lacking of an authorized agreement from TVA for it.
right? That is, the person who signed it, who undertook the formalities, actually was not supposed to be entering into contracts on behalf of the entity. My response, had I been the judge, is, yeah, that sounds like a you problem under the doctrine of apparent authority, which is a thing. If you go look at the doctrine of apparent authority, if a corporation or a company lets somebody run around and act like they have the authority to do something, they have the authority to do something. That is not a problem for the other party to the contract, because how could they ever know? Right? It's a stupid rule, but that's what the court did. The court, one, said, I am bound by precedent in this jurisdiction. I cannot enforce this contract. But you can see the court raging against that restriction, which is why it did exactly what it did with restitution. All right? And that will be, by and large, mostly how these go. All right. Any other questions about anything? Yeah. Yep.
Explanation. So in the book on page 104, it
Yep.
talks about how Xerox put in this statement that they would have bid $10,000.
Yeah.
But it didn't actually constitute a bid because the bid never happened.
Yep.
But then, like a little bit further down, or no, I'm sorry, at the bottom of that paragraph,
Yep.
it says it can't exceed the lowest contract price that would have been obtained had a competitive bid taken place.
Right.
So we're already supposing that a bid never happened.
Yes.
Right.
And that's right. And I think the court, look, because the court is considering this external market check, right, as a way of keeping an objective constraint on the price, it has to listen when other people say, we would have bid X amount, right? But you've already identified the problem with that kind of testimony, which is?
It's circular, right? Because they're saying a bid never happened, but we have to consider a bid as if it did happen.
Yeah, so I got caught. I try not to do war stories. This is one that's still, like, I have the trauma. So we were trying to manage the sale of a bunch of hospitals during a huge roll-up in the early 2000s in which healthcare providers were buying hospitals left and right, and they bought them too fast and they went bankrupt. It was one of the largest bankruptcies of these healthcare roll-ups in the country. And during that, we sold a hospital. Now, the hospital we sold was for a certain price. The problem was that there was some evidence of collusion at the auction. And so it looked like the hospital had gone for a too low price because somebody had agreed with somebody else to not bid against each other. And that meant that we sold, that was the theory, was that it had been sold for a too low price. So what happened was, and we won this, what happened was we got in there and we put then one of the other bidders who'd lost at the auction on the stand, and they said, oh yeah, I totally would have paid more for that hospital. Now it worked, but what is wrong with this picture?
They didn't pay more.
Yeah, they did. There is only one way to deal with this problem, and sometimes I will forget myself and I will use econ speak. This is the problem of interpersonal comparison of utility. I am sorry to use a long phrase like that. What it means is, this is worth something profoundly different to you than it is to me. That is, we can't compare what it's worth to you or what it's worth to me. The only way we ever can compare is to actually put cash on the barrelhead, right? To have a real enforceable offer out there. And so I think that's one of the reasons why the court is treating this $10,000 with a kind of a loose hand, saying like, yes, I do have to consider it, but also there are real profound problems with, exactly as you note, somebody talking about the bid they would have accepted when they didn't actually make that offer and that wasn't actually accepted. Make sense?
Yes.
Awesome. Yeah.
The Fred problem, where
Yeah.
unauthorized signatories.
I love the Fred problem. That can go on the exam.
What is the non-colloquial name of the Fred problem?
There's a bunch of them, but basically it's a capacity argument that the person is not empowered. They do not have the capacity to contract. Like you do not, unless you are my agent or my lawyer, which makes you my agent, you do not have the capacity to contract on my behalf. Right? Yeah.
Could you clarify the statute of frauds a bit, so it can't be applied with services?
I can. We're not quite there yet, but this book doesn't do a great job on the second of our big 5 questions. Our first one is contract formation, second is formalization, interpretation, defenses, remedies, right? It doesn't do a spectacular job on our formalization, and so we've been doing it a bit as we go along. So here it is. There are actually 2 statutes of frauds that you need to know for the bar exam. The first one is not a statute. Often it's a common law doctrine that became statutes in many different jurisdictions. That's the common law version of this. And then there is UCC 2201, which is a statutory statute of frauds just for movable goods. So already our division gives us 2 statutes of frauds. One of them isn't a statute as we look at it. It's a common law list. And that common law list is pretty commonly found in different state statutes. The other one is found largely in the same statute in almost all the states, in 49 of the states, and that is UCC 2201. What does it say? Well, the common law version says certain important contracts must be in writing to be enforced. Where you will make the mistake every time is thinking that certain important contracts must be in writing to exist. You will be wrong. There is such a thing as an agreement which exists but cannot be enforced because it was not properly formalized. You with me? What are these certain important contracts that must be in writing? The standard list, and I'm sure I will miss one, is land, contracts to stand surety for the debt of another, that is, if I guarantee your debt, contracts in anticipation of marriage in some states, and then our big labor exclusion, which is contracts which by their terms, and we will reach this point later on, contracts which by their terms cannot be completed in under a year. Let's try it. A contract to build the Death Star. Is that a contract which by its terms cannot be completed in under a year? The emperor is not as forgiving as I am. We will double our efforts. We used to do a drinking game back, because that was like Return of the Jedi was the only movie we had, and so like every time you missed a line, you had to drink. Rural Virginia in the 80s, I don't know what to tell you. All right, so that is not a contract which by its terms can only be completed in under a year, because it is technically possible, working triple shifts, right, to complete the Death Star on time. Now, Midwest versus Orion is a 5-year franchise agreement, a contract which by its terms can be completed in under a year. No. Why not?
Because it's a 5-year contract.
Yeah, because it's a 5-year term. It's not something that you have 5 years to get done, and if you get it done earlier, great. It's literally a contract for 5 years. It cannot, by its terms, be completed in under a year. Therefore, that was our contractual failure in Midwest versus Orion, right? Our contractual failure was the court probably tended to think, yeah, they had a deal, right? When Reese was, fist bumping and saying, we're going to go do this, the court kind of felt, you got the sense that they did feel that there was a deal. They knew they couldn't enforce it, though, because for this 5-year franchise agreement, they needed to have that. Now, there's one more in answer to your question. So by the way, I've just given you the core breakdown. Land is too easy. On the bar exam, it will be a question about if it's the common law statute of frauds. they will probably ask you either about a contract to stand surety for the debt of another, which is a little known exception, but you'll hear it enough in law school to like have that sink in by the time you get to the bar exam, it'll be fine. The one that they will probably go after you on is contracts which by their terms cannot be completed in under a year because they can play Death Star games with you, right? Okay, cool. The other one on the other side is 2201, that's the statute of frauds for movable goods. Under 2201, there are basically a few requirements. We will look at that when we get there, but for now, it must be clear under 2201A that the contract is for sale of goods. So somewhere on it, it'll have to say like, we are buying, or for stuff that's movable, for chairs, somewhere. You got to get the sense that it's a sale, not a rental, whatever. Okay. The second thing you need is a signature by the party to be charged. The third thing that you need, or an exception to that. And the trick there is that it applies to all sales of movable goods over $500. Now that was real money when the UCC was passed. But the statute of frauds now is kind of swallowing the world now because a cup of coffee is going to cost $500 in about a month. And so we're going to need statute of frauds writings for the sale of a cup of coffee coming up pretty soon. But when it was passed, 50 plus more years ago, $500 was real money. Also, we don't actually have a functioning legal system at the legislative level, and so we've tried to update that, and we can't. I think it's $1,000 for rental because Article 2B of the Uniform Commercial Code, which deals with rentals, got it up by a bit. But I'll have to check that. It might even be 5,000. But 500 is what you need to know for this class and for Uniform Commercial Code sales. That's the statute of frauds. That's the whole thing. There is nothing more. Yeah. For TVA? Cool. The black letter law for TVA is first to know what restitution / unjust enrichment / quantum meruit are, so that I don't have to put the slashes in every time, so that you know that when I say quantum meruit, restitution, unjust enrichment, I'm saying the same thing every time. The second is to know what the basic theory of the case is. A person must return something which was given to them or which they received and which is unjust for them to retain. The third is you need to know what the word unjust is doing in that sentence. Normally, when we see as justice requires, we ignore those prongs. We do not here because unjust enrichment is part of equity, not part of law. And what that means is, for example, if you're a jerk, you can't claim it anymore. Courts will literally say, you come to a court of equity with unclean hands. Like they get a little, on the nose with you. They say, nope, you too were being a jerk. You cannot come here. This is a court of equity, not law. So you need to know that this is a creature of equity, not law. And the last thing you need to know about it is that there are a couple of different measures of the damages for unjust enrichment, and that they track to our subjective and objective theories of the course. That is, it is entirely possible to get unjust enrichment for the value to someone, right? Or the value on the market. But each of those has its problems. The value to someone, how would you know? Unless they put cash on the barrelhead for it. And the value in the market is great as long as you have a thick market. People are doing this a lot, then you can get your comparables, right? But if you can't get your comparables, then there's nothing for it. You're going to have to go back to cash on the barrelhead as your only measure of what something was worth. That's what you need to know. Great question. I do want to make sure I get everybody. Nate, go ahead.
As a quick follow-up, we have an example of a case where subjective damages were awarded, or restitution was awarded?
What do you mean?
Like the court used a subjective test to determine the value.
Sure, let's try this. I contract with you to build a 30-foot tall hot pink statue of Darth Vader in my backyard. Now, the thing is, y'all don't know this yet, but the 30-foot tall hot pink statue of Darth Vader is kind of my bag. Actually, from a number of other, don't do it, from a number of other years, they bought those like pink bobbleheads, And like one of them was just like a Valentine's Day bobblehead of Darth Vader, and then there was another one where they spray painted it pink. And then people started 3D printing the damn things. And if you want to go up to my office, you can see this whole collection of hot pink statues of Darth Vader. Why would I say this? I would say it because it makes it clear that I actually do have a quite high subjective valuation of a 30-foot tall hot pink statue of Darth Vader constructed in my backyard. You can imagine what a 30-foot tall hot pink statue of Darth Vader constructed in my backyard would do to my and all other local property values, right? That would be the difference between the subjective valuation and an objective market valuation, if that makes any sense. Among other things, it helps us resolve a fundamental contracts question, which is, what do we do when people put cash on the barrelhead to contract for things that actively damage their value? Like what if you get a car, a vintage car, and you have somebody put like Pokemon, like have it detailed in Pokemon. You cut the value of the car by a third or something, right? Well, you still get to contract for those things, and we still get to enforce those contracts for those things, even if the valuation is purely subjective. So that's a couple of ways of thinking about that subjective-objective valuation split and why you might use it in one circumstance versus another. Good question. Wait.
If in the TBA case, if they had found out that this contract had been made before they actually received the microfiche, and Campbell never got to give it over, would it be a reliance case, and then would the damages be less?
If he had undertaken substantial out-of-pocket costs in order to begin production, you think probably so. You think probably so, right? And by the way, he clearly had some out-of-pocket costs in this case too, right? Right, yeah. So clearly had those out-of-pocket costs. Also wanted that restitution more, right? Because he was able to get that to be equivalent to the contract price. And so that was his better theory. And indeed, in many of these cases, we'll find that the selection of the cause of action and the selection of remedy is purely driven by how much you can get, rather than any deep theory. You need to understand the theory to get that for your client, but the reason you're going to get that for your client has nothing to do with deep theory. It's just like, are there more zeros? Anything else, y'all? Anything else? Okay, cool. We're going to move fairly quickly through these cases today. We unfortunately start with a couple of cases that are, well, at least with one case that's, I'm really hesitant to start with in terms of contract formation. So I'm going to give you just a brief contract formation primer. It's not long. What do you need to form a contract? You already know. Offer, acceptance, and consideration. And that's everything that you need to know. We're going to have two cases, Ardente versus Haran and Davis versus Satram, which as far as I can tell are basically the same case. They're just driving home the point over and over again because it's so common and so testable. But the reason that we start with Sun Printing is rough. I'll say this, I will answer my first question for you in this one case. Sun Printing is here to decenter you from the basic black letter rules. Sun Printing is not the law. Sun Printing is obviously not the law for reasons that we will begin to discuss. It is not the modern law under the Uniform Commercial Code. It's for sale of newsprint. That's a movable good, so it can absolutely falls under Uniform Commercial Code 2205. But here's the thing. That's not the law now, at all. What they said in this case would not go anywhere. So what they're trying to do is something profoundly different. And here it is. I'll introduce it this way, and then I'll sort of start in with Annika, and we'll kind of talk about we'll talk about Sun Printing. It's here to show you that these real-life contractual cases span more time, are sloppier, are more difficult, are more fact-dependent than offer, acceptance, and consideration can ever be. Offer, acceptance, and consideration requires a moment, a click between the offer and the acceptance. That's the entire thing that we're going to do today. You wanted to know, we've done consideration for 2 weeks. I assume you know what it is now. This is offer and acceptance. Here's what you need to know about offer and acceptance, that the offer and the acceptance have to match. And when they do, and both parties signal assent, there's a click. And the universe shifts. And suddenly there is a private universe of law now that wasn't there before. That's why they need the click. Because if you're before the click, there's no law there. If you're after the click, there is law there. But that is a profound misunderstanding of how any negotiations, except for the most basic possible, work. In which there's a gradual warming up, and people look into each other's affairs, and they negotiate, and then they start trying to get together. Like, and at some point, somebody gets cold feet, and the question for the court is, was that before or after the click? And it's kind of a dumb question, because metaphysically here in the real world, there was never a click. There was just, look, they decided at some point they wanted to do this, and they wanted to do this, and then one party, often the party that's done the counteroffer in question, they want out. And so what we're dealing with in this entire area is not, it's scary that offer acceptance are so easily understandable because they are so impossible to apply. Among other things, what I'd like you to do is immediately, as of some printing, decenter from your mind even this. Who's making the offer? Who's providing the acceptance? Decenter that. Let's try it. I see an advertisement for Kingdom Come Deliverance 2 at a price of, actually it was $29.99 because they knocked the price down and I've been waiting for that for a minute. I'm so behind on my games that I wait a year, 2 years, 5 years, it doesn't matter anymore. I'm still, I just finished another run through of Baldur's Gate 3 for crying in a bucket. And then, but before that was Skyrim, I have not played much. So imagine that I'm doing this, right? And I go into Best Buy. So they have that offer, I see that, right? There's an ad. And then I go into Best Buy and I say, hey, I'd like to get this. And they say, sure, let me take you back. There it is. And then I pick it up off the counter and I say, this is the one? They say, yeah, this is the one. I say, I'd like to buy this. They say, great, let me walk you out front. And then you walk out front and then you go through the cash register and you hand it to them. And then they hand it back to you and you give them money and then you walk out. And only after that point, in fact, I get home. And what I do is I install it, usually a download code. I actually didn't buy anything these days. And I install it and I get a splash screen that's got the contract on it. And I click I accept. Now, do you know where, raise your hand if you know where offer and acceptance were in that sequence. Yeah, me neither. That confusion is not a loss to you. That confusion is a superpower. Because depending on where you characterize the offer and the acceptance, the terms of this deal are going to change. I mean, I'll give you a real easy example. In Europe, and especially in Germany, the contract is the terms that were available for me to see when I left the store. You can't enforce the terms of this extra click wrap electronic agreement that happened later on. In the United States, you can, but the contract was probably formed well before that. You just got the terms later. How does that work? We'll see in one of the worst cases ever written by an American judge. But Judge Easterbrook, I have a grudge. But do you see, what I need you to see right now is you shouldn't know in that whether the ad was an offer. You should be prepared to argue that the ad was an offer. You shouldn't know whether me showing up and saying I'd like to buy a copy of Kingdom Come Deliverance 2 is me accepting their offer of the ad, or is it me offering to buy it, which they accept when they say sure and take me back. And you should not know whether that is them offering to sell it to me when they say, well, here's the specific copy, so I'm going to hand it to you. That's their offer. We could say that with a straight face. I would take money as a lawyer. I would sleep very well that night, right? And then what would be the acceptance? Well, the acceptance would be when I pulled out my wallet and said, sure, yeah, absolutely. And I hand my, I double click on the iPhone now these days. I realized I'd lost my wallet a week ago because I've just stopped carrying the thing. Everything's on my phone now, right? Or was the offer and the acceptance received when I get home, install a thing, and get the splash screen and hit accept? Who flipping knows? That's not the point. The point is you need to be able to identify the differences in law that impact each point in that chain and what it's going to mean if you argue and if you win on any of those given characterizations. That's what sun printing is here to do. It's otherwise a really hard case to swallow. It's very different from almost every other case we've looked at. It's a hard one because it's wrong on modern law. It's just flat wrong on modern law. And then you have to try to figure out what the hell Cardozo's up to. Like, what does he even think is going on here? And he's a famous judge. Why is he doing this? And the dissent seems to be largely right here, and the dissent's probably completely right. So what do we do with it? Well, we use it to talk about why offer and acceptance are a liquid crap way of thinking about long-term contracts. So that's where we're going to start. I've already answered the first question, but if you wouldn't mind setting up sun printing for us, please.
Sure, so the plaintiff, Sun Printing, agreed to buy from the defendant, Remington, who agreed to sell 1,000 tons of paper per month from September of 1919 to December of 1920. In the first few months, there were specific terms for the price and times of the payment. The contract also specifically described the paper sizes and quantities. After these initial shipments, the parties were to agree to a new price and term of its duration 15 days prior to the expiration of each previously agreed period. The price was not to exceed that charged by Canadian Export Paper Company. Remington, the defendant, eventually gave notice that the contract was imperfect and it claimed no future obligation to deliver for this initial period. In turn, Sun Printing, the plaintiff, demanded for the delivery at the Canadian Export Paper Company's rate, since that was the agreed rate that they initially agreed upon. The plaintiff, Sun Printing, brought action to recover damages for non-delivery, but no such agreement on price and duration for the term of the contract was ever reached, leaving the contract incomplete and unenforceable.
Leaving the contract incomplete and unenforceable, which is the black letter answer of this case. Don't even write it down. It's so wrong under modern law, I don't want it to damage your minds. Let's start with it. First of all, let's just back up a second. Is this the first time you've read this case?
For me, personally,
For you personally? Yeah, bet it isn't. You've read this case at least twice before. Same case. Like, I get it, they had different words, different judges, different times. We've seen this case twice before. Where have you seen this case before?
not exactly sure.
Okay, we can call in co-counsel. Was that a hand or is that, no? No. Yeah, go for it.
It's a requirements contract that's similar to
So it's almost identical to NIPSCO. Tell me why it's identical to NIPSCO. This is the same case as NIPSCO.
Because two parties came together without agreement about duration of the time and also the specific requirements that are going to be for longevity.
Well, specific requirements is giving somebody else a free swing at the second case. Specific requirements, what's the other case? I said we'd read this case twice before. It's Eastern Airlines. We've seen this case twice before. In both cases, we have multi-year, these long-term contracts, remember, that I was telling you about? We have these long-term contracts. And what's the problem with setting a price in a long-term contract? Prices change, and so what do? Every time, they try to wiggle out because it goes south for one party or the other party. Notice really quickly, did NIPSCO or Eastern Airlines let them wiggle out? Did NIPSCO or Eastern Airlines fall for the idea that, oh my goodness, we had a long-term contracts, the prices were all over the place, and because the prices were all over the place, we'll call the whole thing off? No. Cardozo, you dope. No, they didn't. So, why? What did they do in each case to solve the price fluctuation problem? They knew. They pick a benchmark and they peg it to the benchmark, which they did here. What was the benchmark, Annika? The Canadian Export Company. So when they said that the contract was incomplete because the parties didn't specifically negotiate a price, your response should be bullshit. And by the way, that is true under modern law, under the Uniform Commercial Code. This is not a UCC case. Unfair question, Annika. Why is it not a UCC case? This is totally unfair. Well, first of all, can you move newsprint? Like you picked up a newspaper? You can, like last time I checked, right? You chased the dog with it, right? Movable. Crumple it up, throw it. Seems movable. That's clearly the UCC, right? Anybody want to take a crack at why this is not a UCC case? Yeah, this is before the UCC. Right? You got to watch these old cases. Okay, so this is before the UCC. Total unfair trick question. So UCC hasn't been passed yet, and in fact, we have everybody's firm prediction here as to what's going to happen when the UCC does this. They're letting nobody out of this deal, right? Because you've set that benchmark to a long period of time in order to manage price volatility. The whole idea that the parties never contemplated that the price would need to remain flexible during the period of a long-term supply contract just becomes nonsense on stilts when you're looking at the law specifically written for long-term industrial business-to-business contracts, which is mostly what the UCC is. It's also business to consumer. That was a mistake. They should have separated them out. But mostly this is about getting widgets on trains from factories to other factories. And to say then, oh, the parties left the price term open and set it to a benchmark, that makes the contract incomplete. Can you see what absolute steaming nonsense that is? Okay, but that's not exactly what Cardozo said, right? What was his excuse for really saying, yeah, I get it, they set a benchmark, but they still didn't really tell us what the price was? Because he's right about one thing being left indefinite.
So he was saying that the benchmark could fluctuate over time and was an inherent risk. And then he started talking about options.
Absolutely. Oh, yeah. Oh, fantastic. Yeah. Okay. This one we do have to talk about. Why is he worried not that it would be dumb if he were just worried that the parties had left the price incomplete if they'd locked it to a benchmark. If it's a stupid benchmark, NIPSCO. If it's a benchmark that did something squirrely, Eastern Airlines, right? Fine, the court will just enforce the benchmark, which is what they did in both of the, whoops, I got so excited I lost my pen. Did it in both of those cases, right? But the time, the relationship of the time, and here I hate to give you the gospel according to Fairfield, but this is something that I will talk about a lot. Cardozo's problem is that leaving the time unconstrained creates what I will call a free option. Now, we talked about options in the past, right? With Restatement 87, where we said a recital of consideration is sufficient to support an option. We talked about that, right, in Laporte versus Blum. And I said to you that there was going to be cases on the bar where you were going to get a firm offer under 2205, kept open for no longer than 3 months by a merchant who sells that kind of goods, and they sign it, and you can keep it open for 3 months without consideration. But what I haven't talked about is the problem of free options. Let's try it this way. We're going to jump to the end of the class. So let's say that you and I contract to buy a car. I agree to buy your car, you agree to sell me your car. And then you breach. Now we all know, because we've already skipped to the end of the class, what I get to do. I get to go buy as close to that car as I can from someone else, and then come and sue you for the difference between what it cost me to get it from somebody else and you, right? Here's the thing. How would you feel if I just let that ride? If I just took a year to buy that other car? Like, we know you breached the contract, and now I take a year to decide which way the car prices are going.
Well, the prices are going to fluctuate, so I'll never know where I can stand.
Yeah, because what happens if that price goes way down during that period of time? The price is going to fluctuate. What happens if the price goes way down?
You're better for it.
Yeah, I am better off for it. What happens if prices go through the roof?
It doesn't really impact you at all.
Because?
Because you're going to get your money back on it.
Right? Because they're going to make me be the insurer of as the breaching party, they'll make you be my insurer against price risk, right? Do you see it? Do you see how leaving the price term open? Look, if any of you all are stock trading and you get a fixed ability to not pay anything if it goes up, but then somebody else has to pay if it goes down, or vice versa, like, call me. We will make $1 billion. It doesn't matter. It's heads I win, tails you lose. That's what an option is. You have to pay for those up front, or else you're getting a free option. This is one example. The first example of what I mean when I talk about a free option is time in a marketplace that moves up and down equals money, and it's all in one direction at the hands of the party who's not acting as the insurer. It's not on me. Can you see that as of the point where we decide you've breached, I don't care about the price of cars anymore? Like, I might try to get a little bit extra if it goes way down, but otherwise, if it's going up and up and up, and your damages are going up and up and up, zero beeps given, right? I don't care. That becomes something that courts are starting to constrain. So, Gene? Yeah.
I was just going to ask, wouldn't the fair remedy be the value of the car in a situation at the time the contract was made?
The value of the car at the time the contract was made.
Yeah, so like if there's no fluctuation in the order.
Okay, there's a whole bunch there, and we don't have a lot of time, but let's try it. Sure, and often in some cases like this, that means your damages are zero. In fact, they usually would be. I don't know what kind of car you drive. We'll assume that it's, we'll assume it's worth something like, 10 grand. Mine's like 3 because it's exploding. And it's got that plastic thing at the bottom ripped off. But let's say it's worth 10 grand, right? And then I replace it for another car at 10 grand. What are my damages? Zero, right? And in fact, that's in almost every mass market transaction, your damages are functionally zero, right? Let's say that a computing company fails to send you a laptop. And so you buy it because it's a competitive market at the same price from somebody else. Your damages are zero. Happens a lot, right? The value and the price are the same. The price is an example of the value. We do have a subjective versus objective. Value is objective. Price is subjective in that particular case. One party's put their cash on the barrelhead. That's how you know that they actually value it at that rate. Okay. All right. What I need you to take out of Sun Printing, it is not the law. Under the Uniform Commercial Code, if you do not set a price, what will the court do? You now know how the UCC works. It is the dark side of the force. Quicker, easier, more seductive.
You'll look it up in a book of some sort.
That is, if you do not agree on a price, the court will set a price. What will they call it? Fair market value. Another way of talking about this is a reasonable price as determined by fair market value. Right? And by the way, if you don't set a time, what's the court going to do? It's going to set one for you, and what's it going to set? A reasonable time for that market and for that industry. That is going to do the same thing. And are those courts going to have a dark night of the soul because the contract is incomplete? No, not remotely. They can't. That's not how these long-term contracts, where we know the price is going to go up and down and where we know it's going to be renegotiated, that's just not how any of this works. So I need you to know, one, that this is not the law. I need you to know, two, this is exactly why we have the UCC and why the UCC changes the rules. Three, I need you to know Annika's insight about free options. That not now, but later on in the course, we're going to become deeply concerned about heads I win, tails you lose. The first time we saw heads I win, tails you lose was when we started talking about illusory contracts. I know, illusory contracts everywhere. But we were starting to talk about that, and we said, that creates you promised to sell me your car for $10,000. I promise to buy it for $10,000 if I feel like it. Can you see how that's the same damn problem? Because if the price goes up for those cars during the week, I buy the car at $10,000. If the price goes down for cars during that week, I go buy it from somebody else. It's a free option. Heads I win, tails you lose. In the face of market volatility, I can't lose. Maybe I need to pay you for that option. If I'm getting the benefit of the option, maybe you should get paid for extending that option to me. And so we'll see these free options all through this course. It is a major silo and a major theme of the course that, although it's funny, car dealers can give you a functionally free option through 2205, the firm offer rule. But we already talked about why they do that. They're getting something for the option, so it's not really a free option, is it? But where courts begin to detect that what's really going on is that the parties had promised something for something, but one party's interpretation turns that into heads I win, tails you lose. Court's not going to go for it. It's one of our major markers for when the court is going to start to rebel against the arguments that they're being given, is if they detect that free option. Here the free option is time. Cardozo's not wrong. The solution, though, is to not call an obviously concluded. Like, does anybody think that the parties didn't intend for a contract here? Yeah, it's just he just completely misses the mark. Like, the dissent's got this. They obviously intended for there to be a contract. They obviously settled out the contract. It wasn't incomplete. None of that's real. The one thing that's real is, watch it. Time is one of the major ways of hiding a free option. Okay, great. Any questions on that one? It's a hard one. We're going to move through the others more quickly, but I did want to show you that one because it is otherwise going to infect your mind and be like this counterexample. You're like, but sun printing. That's what it's doing in the book. That's a dangerous pen. Okay. Sometimes I think you're going, all right, cool.
Sorry.
No, it's okay. It's all good. Okay, let's move into offer and acceptance then. These we will move through more quickly. Nick, could you set up Ford Motor Credit for me, please?
So, Miss Russell saw an advertisement to buy a Ford Escort at a price of $7,826 at an 11% interest rate. She went to Monticello Ford to purchase the Escort, and they said that she did not qualify for the 11% after they went to a couple financing places. So, her and her father signed off on a contract to buy it at 13%. Has it, then she's not making her payments, defaults, or credit, repos the car, and then they sue, saying that the contract was false under, what's the wording? I can't find the exact wording, but it was.
Yeah, well, because let's just play our game, our best buy game. Under her theory of the case, where was offer? The advertisement. What was acceptance? Her going to the store to buy it. What would the terms be if we use this David versus Satcham rule? The offer and the acceptance are the same. By the way, you can do that. You can do it by exactly mirroring what the other person says, or you can just say yes to them, right? So they said, here's a contract at 11%. She says, yes, under that theory of the case. Is there a contract? Yeah. Well, what are its terms? The 11%. Does it matter, and this is where I'm going to really start messing with you, does it matter if that's true? If that's true, if the court accepts that, does it matter that Fred in accounting, I'm going to really start pissing off somebody actually named Fred, that Fred in accounting like surreptitiously changes the number to 35%? Is that going to change the terms of the contract? Yeah. Is that going to change the terms of the contract? I mean, if it does, I can write up a contract right now for your car for $200. Sign it. Here, I have a contract right here. What's the problem with that picture?
There was no acceptance.
Yeah, there was no acceptance because those weren't the terms. You gotta watch it. This is the hardest thing, I swear, on a stack of whatever you care to swear on. This is the hardest thing for law students to get, is this difference between the existence of a contract and its formalization. And what I need you to understand is that courts and you will constantly consider the formalization to be the terms. This will get so much harder later on when we deal with rules for including the evidence of what y'all said when you shook your hands. There's a lot of rules about when you can bring that evidence. Saying 11%, 11%, I say 11%, you say 11%, we shake. Is there a contract? Yeah, is it enforceable? No, why is it not enforceable? Sale over $500. Even these days, that is 2201. That is our, what area of law are we under? Uniform Commercial Code, 2201. We use the Uniform Commercial Code because the car theoretically moves. It is a Ford. I'm driving one right now. I'm allowed to say this. It's more of a like Schrodinger's movement, really. It could move. I'm bitter because 2 days ago I got in my car, I had the key, and I hit the button, and absolutely nothing happened. And in a hybrid, you're just like, wait, I don't know quite what to do about this. Like that is, it turned out it was just the battery, but like just nothing. Okay, we're under the UCC. We would use that Uniform Commercial Code 2201 statute of frauds. We do need a writing. The point I'm trying to tell you here is the writing may or may not reflect the actual terms of the parties. That's why we always separate. Is there a contract? Cool. Has it been properly formalized? Cool. What are its terms? Those are our first 3 questions of the course. Formation, formalization, interpretation. But we keep those analyses absolutely distinct. You may not, with the Ghostbusters, cross the streams. You may not consider more than one of those first 3 questions at the same time. I'm telling you this for your exam, for your practice, for your life. Do not cross the streams because courts will mistake the formalized document for the agreement of the parties all day long. So, what must be true here? Because the court eventually says, nah, this is clearly 13%, but in order to get that result, what does the court have to say about offer and acceptance?
They said that the advertisement was an invitation to bargain.
Okay. The advertisement was an invitation to bargain. Cool. So what would the offer be?
What they were doing at the store.
What's our next offer possibility, David?
The offer is just that they're willing to negotiate in the first place.
Well, no, because he's just absolutely black letter law. To be clear, for reasons we will discuss, advertisements do not count as offers. But it is not a legal reason. There is no theoretical reason, there's no reason of theory that that could not be true, right? I mean, it's just an electronic transmission of something. And if I send you an email and it says, offer to sell my car, and it's got a bunch of details, that turns out to be an offer to sell my car. Although why it is that Toyota gets an exemption from that when they put that same set of words on a screen alongside like a 10,000 mile powertrain warranty or whatever the hell, they get a pass. I do not. It has nothing to do with law. We will try to figure out what's going on here in a minute. But for now, it can't be that. Where's our next offer point? Yeah. Yeah, so she walks in. See, it doesn't solve the court's problem. When the court pulls this bullshit, it doesn't solve the problem. Because here's what happens. She walks in and she says, I would like to buy a car. And what term is she offering?
At that price, 11%.
Yeah, at 11%. And under the old rule, the common law rule, which is not really the rule anymore after we get to the worst case in contract law that anyone has ever written. That one's coming. It's like Jaws. You can hear it on the horizon. But up until that point, and in fact, Judge Easterbrook, I'll try to moderate my language, even says things like the offeror is the controller or the master of the offer, which means if the offeror is the master of the offer, if she walks in and says, car 11%, and they fist bump, what's the contract? Car 11%. Will it change the terms of those contract if Fred in accounting then writes 35% in there afterwards? Nope. We may have a problem where we can keep the evidence of what they said out of court, but that is a problem for a later date. It does not change what the parties actually did and what the terms of the contract were. Okay, you can see the problem then. Because the court kind of does that. So what must the offer be? Well, if she offers to buy the car, then she's the master of the offer, and what are the terms if they shake hands with her on the shop floor?
What are the terms if they agree?
Yeah, if she walks in, she's like, I'd like to buy the car, saw your ad, 11%, it said so on the radio. They're like, heck yeah, fist bump. Yeah, then it's that agreement. Does it matter that Fred writes it up differently in the formalization? Nope. What's the offer got to be?
The offer has to be when they enter the contract.
The offer has to be when they enter the contract. Well done. That is. I need you to see this. Was the ad, in this class, was the ad the offer? Could, who said it? Could be. Was her walking into the store the offer? Could be. Was the offering of the contract the offer? Could be. Does it change the outcome of this case as to which of those turns out to be what the court accepts? Yeah. Now, why in the hell is the court basically saying the ad can't be the offer because she would win? Her offer can't be the offer because she'd win. The offer has to be over here, which is the third moment that we could find an offer in this case, so that they win. I'll open this up to everybody. Why is the court doing that?
I mean, this is the only time that both the offer and the buyer are like in the same room.
Whoa, 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 whoa. I mean, like, I get it. I get it. We don't know exactly what happened. But remember, we just said our sequence of events is they put up an advertisement at 11%. She comes in and she says 11%. They say, heck yeah, fist bump. Then they come up with the contract. So if that's our theory, I get it that that's not exactly what happened here, right? But if that's a theory of the case, it's not entirely true. I'm seeing a lot of hands. Valeria, yeah?
Oh, so I was going to say that technically it would, like, the reason why the court wants to say 13% is because she was handed the contract, she read the contract, she was supposed to read the contract, and saw the 13.75 APR percent, and she still went through and signed it.
It's true. As a technical matter of contract law, would that change the terms of the contract if you'd already previously agreed? No, and by the way, do people read contracts? They do not, and do courts know that? But Valeria is right. This argument happens all the time. What I'm doing is I'm showing you how to unpack. The court delivers this as if it's like from on high.
The court's not interested in people getting loans that they're not authorized to have.
The court's not interested in people getting loans that they're not authorized to have. You were saying, yep.
The court's like objectivity, something, like people can say whatever.
Well, that's a huge problem. In all these cases, the court is absolutely addicted to the writing because that's all it's got for the most part. But it also is very aware that if there's other evidence, it either needs to listen to it and change its mind or exclude that evidence. We will see that later on. Yeah? The 11% was impossible? Can you use your hand up?
Oh, yeah, because not everyone qualifies for that 11%
Okay.
offer.
What's changed here? Because we do have one of these cases. It's like Webb versus McGowan. Remember I told you about that past moral consideration case that is there to make a point. It is no longer the law anywhere. That's Lefkowitz. Did you notice the discussion about Lefkowitz? Sometimes this will be called the Lapin, lapin, because we're into French. Lapin being rabbit. Lapin stole. That's a garment that you're going to wear around that's a rabbit fur garment. In that case, they advertised for a lapin stole. They said the first 20 people who get here are going to get that lapin stole at a ridiculously low price. She shows up. They try to up the price on her. It's identical facts. They try to up the price on her. She says, absolutely not. The court agrees with her. I mean, first of all, let's just even try. What would we say? How would we make that an enforceable contract? Leon?
Because they offered it in limited quantity, it is widely applicable, whereas like in this case, like they don't have infinity of.
They don't have infinity of these things, and not everybody qualifies. What changed? Was it contract law? Between the lapin stole and Russell, what changed?
The offers are different.
The offers are different. In what way?
The Ford offer has a stipulation. You have to qualify for that.
Ford offer has a stipulation, although they don't. Like if you go look at any Toyota commercial, they just say, we'll give you this, and no court will ever enforce it.
I was going to say, qualifying for what the 11% was a term of the contract.
But it was not one apparently that was, I mean, if it was made clear at the outset, right, you would get that extra play. There's something else going on this qualification. Let's say everyone who possibly could in the world would have showed up and said, I want a car for 11%.
Well, those who qualified, they did get the car for 11%.
Those who qualified did get the car for 11%. Why is the court going with this? You're right. Everybody's on this qualification level, but there's something else going on here. Yeah?
The value of the car goes up.
Value of the car.
So
might go up, except we know generally what happens to cars after they go off, yeah?
It's kind of a change, but I would say that the court's not going to enforce this because it would ruin the entire used car dealership industry.
Oh, now we're on to something. Hey, hang on a second. They put that Pepsi case in there, right?
Oh, yeah.
Yeah, cool. The one that's like for 60,000 Coke points or Pepsi points, you can get a Harrier jet. And then the guy went and got them because it turns out it wasn't all that expensive to get 60,000 or however many thousand points. And then the court said what?
No.
No. Under Lefkowitz, mind you, the theory was the presence, getting the person to come into the shop and be one of the first 20 in line. That was consideration, and so therefore there was a fully enforceable contract. But the court changes its mind between Lefkowitz and Russell because of the difference between, not the law, but the difference between old school mom and pop newspaper advertising and mass media. What you're looking at here is what technological shift does to market change. That there's no way anyone who runs any commercial on mass media can actually be held to every one of those if they were offers. They don't have that many of them. That's just not what the entire industry of broadcast advertising does. Now, they don't have the guts to say it because courts generally want to pretend like they're acting purely as a matter of black letter law. But if you can see any principled difference between Lefkowitz and Ford Russell, you are making it up, y'all. There is no difference whatsoever. In both cases, they put the ad out there. In both cases, the value was that they got customers to come in, and in both cases, they baited and switched them, and it was kind of a jerk move. And the court gives no beeps, and in fact, does the same for the Harrier jet. Just says, mystically, out of nowhere, even though you were supposed to get like some special funny money in order to get the Harrier jet, court doesn't care, and it relies on this invitation to treat. That's the black letter law you need to take out of this case. That a mass media broadcast advertisement will not be taken as an offer. It will be taken as an invitation to treat. And the reason has to do with the industry model selected and the court's willing to countenance a little bit of light fraud in order to let that happen. A little bit of light bait and switch in order to protect this new mode of blasting it out to more people than could it can't be an offer to everybody. Do you see that? It can't be an offer to everybody. There must be this qualification stuff in there. Okay, cool. I need you to see two things about the case. One, that this is the invitation to treat rule. Two, that the invitation to treat rule largely is what I will later on call the Easterbrook dance. It's the dance of the lawyer and judge who are going to move the moment of offer and acceptance opportunistically to find the contract that they think the situation merits. It's not that offer is a moment or that acceptance is a moment. These are arguments made about different moments in a longer timeline of negotiation, trying to find a lock-in point that never existed but serves to validate the court's view of the form of the transaction. Any questions on the black letter law of Russell? Lefkowitz is still out there. You can argue it sometimes. Good luck. It's like Webb versus McGowan. It's not really a thing. This is the invitation to treat rule. Okay, I had one more hand. Yeah. Invitation to treat, yes. That is invitation to negotiate. Note that it doesn't solve the problem, though. Sure, call it an invitation to negotiate. Call it an invitation to treat. She did. That was her offer. She's in charge of it. If they accept her offer, the offer's on her, the deal's on her terms. All right. Any final questions about Ford? Okay. Then we are going to move straight across. We see this one twice. Yeah, go ahead. Lucas.
Sorry, I do have a final question.
Yeah, fire away.
So say you were to agree that the contract was accepted when she walked into the store and accepted the advertisement.
Yeah.
Could they get out of it by claiming impossibility because they couldn't get anyone to finance it at 11%?
No.
They were just
Right. It's too hard, unless that's an express condition. Financing is often an express condition, the ability to secure financing on both seller and buyer's side. but unless that condition is part of the contract terms as negotiated, no. Because you can see why, right? Because otherwise, saying, yeah, you can get out of every contract by being like, I don't have enough money to pay my debts. Oh, that's not how any of this works. Yeah, I'm out, right? I made a shitty contract, I'm out. No, that's not how that works at all, right? Exactly. Okay, let's move then into Davis versus Satcham. Bailey, if you wouldn't mind setting it up for us, please.
Yeah, so in 1984, Davis basically was appealing from a district court summary judgment because Satcham apparently breached the contract for the sale and purchase of a mobile home park. And so after like the negotiation, Davis sent a letter of intent to Wisdom, who was like the operator of the lawyer of the sale. And then Blair changed the terms of agreement and then sent it back, and then they negotiated again, and then David submitted an unsigned commercial purchase agreement and deposit receipt containing terms not actually included in the original letter of intent. And so then Blair signed this, but sent it back with a handwritten edits, and then one of them was saying that the contract needs to be agreed upon by the seller's lawyer. And so Satcham and Blair sent the letter to Wisdom saying that they would pass it, like they would pass on the agreement. But then, and then Wisdom forwarded this to Davis, and then Davis sent a letter to Blair saying that they were ready to perform, and they had like the $10,000 check. But then Satcham returned the check uncashed, said, "We're not doing this." And so Davis was alleging that Satcham breached contract of sale and purchase of this.
For the sale and purchase of this agreement. Okay, cool. Let's get the black letter law out of the way here. First of all, what law are we under?
This is common law.
This is common law. Why is it common law?
Because you can't move local.
You can't move a mobile home park, right? You can't, that's land, clear, textbook, common law. Great, cool. Watch out for mobile homes themselves. I'm deathly serious. I'm deathly serious. Here's why you watch out for RVs and mobile homes in particular. It is because sometimes they can be fixed to the land when you hook up their utilities, and therefore they're not movable. Sometimes they are movable because they're unhooked from the utilities. And more than that, they are worth enough money to be worth going to court and paying one of us the fees that you will enjoy billing your clients for. And therefore, that combination of those three things mean we get a fair few RV cases because they're like contract for the sale of movable goods. We will not have a published decision about this, right? Or that, or anything else mobile that you can find in this room. There will not be a published decision. An RV? Oh yeah. Mobile home? Absolutely. So do watch out for that. But the park, like, no, right? We're not moving that at all. This is clearly on the common law. Great. So the common law rule then for what we have to do, what's the fit between offer and acceptance? What do we need at common law to form a contract? What's that fit? Consideration means there has to be something for something. There was clearly something for something in this agreement, right? There was going to be money for a mobile home park. If there had been a contract, there would have been full consideration. But what do we need for the two to click?
For the same terms to be the same.
Yeah, and that's called that's called the, anybody know it? Yeah. The mirror image rule. That's the way that we tend to talk about that. At common law, for there to be a contract, an offer and an acceptance have to mirror each other. There are two ways for an offer and an acceptance to mirror each other. In reality, there is only one, but let's do what the common law thinks first. What are the two ways that the offer and acceptance can mirror each other? Well, first of all, they don't in this case, right? That's
Meeting of the minds?
and we'll get to meeting of the minds in a minute. Absolutely. But here, notice, do these things ever match up? No, they don't, and that means there's no contracts. So that's what's going on in this case, right? That is, the offer and the acceptance never quite match up. Anybody here do improv? Ever? Yeah, cool. What's the core rule of improv? Yes and. So yes and, great for comedy, not good for lawyers. Because what happens at each point, Bailey, what happens when the one party says, we're going to do this, and the other party says, yes, and
It's a completely different, it's a counteroffer.
it's a rejection and counteroffer. And then this person says, yes, and then it's a rejection and another counteroffer. And the problem is they go back and forth. How do you stop that chain? So there's two ways that you get the mirror image rule. The one is that the offer and the acceptance have all the terms and there is not a goddamn thing different between them at all, right? That's offer and acceptance, they're the same. But that's never how it happens. How do you stop the chain?
When they both agree on the same piece of paper.
Yeah, when one party says yes and the other party says yes. No flipping and. Yes. Once one party gives you a bunch of terms and the other party says yes, or does something that signifies that they do accept the terms, that's overwhelmingly how we get the real life application of the mirror image rule. All right? So we've done a bunch of black letter law here. We've laid out the mirror image rule. We've laid out the counteroffer and rejection rule, that is an acceptance which purports to be an acceptance but includes additional terms, is a rejection and counteroffer. And then we just play tennis until somebody says yes and stops with the and. All right? That's the case. There's a bunch of things there that we should look into. First of all, why did they keep doing this?
I don't know. I think that they kept doing it because they, I guess they wanted, it was the unfavorable tax consequences that were going to happen to
Yeah.
stage one. They were, like, that was at the end.
Yeah.
Basically, like, this is not going to be good.
Right, so they were squabbling over something that they should have just out and out negotiated, right? And then one party wants out of it entirely. To be clear, this was not a deal where we had a rejection and counteroffer, a rejection and counteroffer, and rejection and counteroffer. Did both parties want this deal to go through? Yeah, like it seems real clear that both parties wanted this to go through. And yet, after they'd gone all the way down this road, one party gets cold feet, sends it to their lawyer and says, let me out of this, right? Which is the practical reason. This is not the legal reason, this is the practical reason. And it's always the practical reason. And it's what's going to happen to you. Your client's going to have had you working on a deal for a year, and then they're going to come and say, I don't want this anymore, get me out of it. That has nothing to do with the legal doctrine of counteroffers, right? That's that fit between what your client wants and the legal doctrine that we've been talking about all semester so far. Okay, cool. So that's what's really going on in the case. One party got cold feet, pretty standard story. Also then, we've got the legal doctrine, mirror image rule, and the counteroffer rule, and rejection, and rejection, and rejection. Any further questions about the case? I think that's pretty clean. Yeah.
I do have a question. So something that I put down here that I think the formation of a contract may be conditioned upon like the act of a third person, like that lawyer portion of it.
Yeah.
So I guess is like the whole reason why, like in my mind, the whole reason why it couldn't even go through, even if that like you had agreed upon everything,
would be
there was no signed by the lawyer. Like,
it wasn't signed by the lawyer. Okay, that's the argument. Let's just erase everything else about the case. Bailey has made the winning argument, by the way, this is often the winning argument, saying this wasn't signed off by a lawyer. Anybody want to attack that crap? Scott.
I mean, it was just a form. It wasn't like they weren't really going to have their lawyer look at it.
They weren't going to really have their look at it. It was just a form. No, that doesn't work, unfortunately. Like Chief Justice Roberts says, Chief Justice Roberts said, I know nobody reads these contracts. We don't know what to do about it. That was a quote at like a university presentation. We don't know what to do.
Well, a lawyer is your agent.
So?
If the court's going to accept that a lawyer's has authority, they're definitely going to accept that you have authority to.
Yeah, and what do we call it? It's a fully illusory contract, right? Completely illusory. That is, what's wrong with finding a secret illusory contract? It makes the contract heads I win, tails you lose, and we call that what? Okay. We call that a free option. Do you see it? This is the first time we're going to start using this language like, nope, there's the free option. Every time somebody's sneaking in a contractual interpretation or an interpretation of events that lets them go, oh yeah, heads I win, tails you lose. Not what we want.
So would you say this is good business on the part of
I would say this, if your client wants the thing, and this is a freebie for whoever I ask to do Ardente here in a minute, If your client wants the thing, what do you tell them to say about the damn acceptance? And here we will quote Ghostbusters. Ray, if someone asks you if you're a god, you say yes! That is, if you want the thing, if you want the deal more than the details, say yes to the deal. Stop trying to get more by upselling. Upselling in contract formation does not pay. I understand that this is key for salesmanship, but it does not pay for contract signing outside of the UCC. Oh, by the way, the mirror image rule is the first casualty of the revolution when we get to the Uniform Commercial Code. They provide a rule which will give you nightmares. You will lose sleep over it. I will make it incredibly clear. There will be a flow chart. You will never make a mistake on it. You will thank your lucky stars when you get out into practice. But the UCC abolishes this. Anybody know why the UCC just absolutely abolishes this mirror image rule? Anybody ever done a purchase order? What's a purchase order look like? Like a real factory purchase order. To a form, right? So by the way, the rule that we replace it with, here it is on the horizon, dun, is called the Battle of the Forms. Dun. So that form has got some nice places, dun, on the front of it, right? By the way, you ever flipped one of those over? What's on the back? A whole pile of what's called boilerplate. Uh-huh. Now, you know what? Anybody here ever done an order confirmation? Which is the seller's version. There's a purchase order and then there's an order confirmation. What do you imagine they look like? Same thing. What's on the front? Bunch of things that you fill in. What's on the back? Opposite boilerplate. Now, the problem here in the Davis versus Satcham is the parties called the deal off, which was clearly supposed to be going through. That's not the standard deal. The standard problem in an industrial context is the deal goes through. And 2 years later, somebody has a cow. Right? What was the contract? Was there ever a contract? What do we do now? We can't have the mirror image rule. That's not how anyone acts. And so they had to replace the mirror image rule with its dark side of the force counterpart, quicker, easier, more seductive, also destroys planets, the Battle of the Forms, which we will get to later on. So hold that space in your mind, it's coming. But we've done this. Okay, cool. Any other questions on any of this before we move on to the next one? We're moving through these pretty damn quickly. All right, I'm going to leave Ardente versus Haran open for a volunteer because we'll rapidly here get into the other ones. But let's move through Davis. Actually, we've got Davis, then Colfax, yeah. Okay, then Gene, if you wouldn't mind setting up Colfax for me, please.
Sure thing. So Colfax does not typically show up to union negotiations as they are a small printer, but they are sent a summary after union negotiations, and they are allowed to either sign onto the agreement or negotiate as necessary based off of the summary.
Yep.
This happens, and they are pleased with what they believe are the terms, and that they can now use less men per printer that they have. However, this is not what the union meant, and the contract now also includes an arbitration clause. Colfax signs to agree based off of the summary. The copy of the actual agreement is then sent to Colfax, and that has a typo that supports Colfax's initial interpretation, but they are later sent a corrected version that outlined the union's opposing intent to Colfax's understanding. Colfax sues, saying that there was no collective bargaining agreement as they did not agree on the terms, and they lose in trial court on this, but they later appeal.
Okay, so far so good. So let's bear down on this. First of all, what's the real fight? Why does the union want this to be 60 inches and lower, and why does the employer want this to be 60 inches and more?
Well, if the union is acting on the workers' rights, they want more people hired so that they, more. It's better for the worker in their view, and Colfax looking to save money does not want to give out more money to more workers.
Seems right. And if we were going to be nicer to the union, we would say it's not just a matter of right? Not just a matter of number of people hired. We would also say if there are more people on means more people on, then it's a matter of safety. So they might not want to lose, right? We're still talking industrial printing, and I don't know if you've seen people lose fingers, but people lose fingers. All right, so there's at least this, that's the core fight, notice, right? And you've read yourself the notation in the agreement, right? Is it clear what it meant? As freaking mud. Now, if it were really unclear when it meant, then we need to get into this. Part of the problem with Colfax is, I'm not sure y'all get what it's doing in a story about offer and acceptance. And that's because you're being taught the new version of contract law. When I learned contract law, it was not offer, acceptance, and consideration. When I learned contract law, it was offer, acceptance, consideration, and, as was already mentioned, meeting of the minds. What's the meeting of the minds story?
So the meeting of the minds story essentially is that you have to mutually agree on what each term means, so that way you can carry out the ordeals of the contract itself, and there's no confusion or bickering about you said left, but really you meant west.
Yeah, I love your aspiration, right? We have to agree on what each term of the contract means. You ever found yourself in a political discussion being in violent agreement with somebody? I didn't say disagreement, we know that, we've been outside recently. Violent agreement. What's going on when you're in violent agreement with somebody?
They're misunderstanding something that you're saying. No?
Yeah?
More like an echo chamber, and just keep weaving it more and more.
Keep more and more like an echo chamber, but then we got somewhere in between here. During this thing with the hospitals that I keep talking about, because I'm clearly dreaming about it this week, it turns out that we won that case. And the court said we won, and I started to explain to the court why the court was ruling for us on the wrong grounds. I have never been chewed out so hard by a partner in my life. He said, "You shut the beep up. What are you doing? Why would you do that?" First of all, it's me, right? Like, I mean, you know, with Neil Brennan, you say, like, if you'd rather be happy or be right, I'm the only one who's gonna be like, oh, right? But second of all, what was going on? The court agreed, we won. I agreed, we win. You still don't understand each other. Look, y'all, the basic tragedy of human existence is that we can communicate through language on a set of agreed upon symbols enough to want to kill each other, but not enough to really understand each other in any fundamental way. Talk to anyone long enough, and you will begin to notice something, which is that they are using every single word slightly differently than you are. It's just the nature of the human condition. This is just how language gets constructed. That's why words shift meaning over time as more and more people begin to use it one way or the other way. That's what's gone wrong with the Constitution, among many other problems. So, when we say the parties have to have mirror image not only of the words, but of their minds in order to form a contract, what do we think about that?
Aspirational at best.
Aspirational at best?
I thought there was a funny quote in the ruling where it's like, courts can't read minds, they're not genies.
Yeah, so courts can't read minds. So it's weird that we're looking for meeting of the minds in a case, in a contracts course, the fundamental rule is which? What's the fundamental rule of this whole dang course? It's also wrong. The opposite of a small truth is a lie. The opposite of a big truth is the other truth. What's the fundamental rule of interpretation of this course? How are you going to figure out what words mean, given that people attach different meanings to them?
You look at their actions.
You look at their actions, or in the case of contract law, you ask for clarification, which is, by the way, the single most important thing that anybody can say in this particular case and explains it. I want you to hold that thought about asking for clarification real fast. Who in this case should have asked for clarification? Yeah, why? Yeah, they were supposed to agree to the union. Yeah, Nick?
Because it was ambiguous.
Because it was ambiguous?
They were gambling that it would be their interpretation.
Ah, because they were gambling that it would be their interpretation, which means who knew that it was ambiguous? Yeah. Who didn't know that it was ambiguous? Who's going to win the case? Every time. This is, if we do this from law, it'll take us a minute. If we do this from economics, this is our core example of the cheapest cost avoider rule. We'll get to black letter law and I'll nail it down for you in a minute, but I need you to be aware that throughout all of these, and this rule will show up in about 4 different places in this class. It's going to be the same rule over and over again. We're talking about restatement 20, misunderstanding now, but wait till we get to whose interpretation should we use. That's restatement 201 and restatement 221. And there's also some restatements in the 50s that we'll get to on mistake of fact. It's the misunderstanding, mutuality, and mistake. They're the 3 M's. It's the same argument over and over again, which is, what if I say, I agree to sell you my car, and you say, you agree to buy my car? What car did I mean? What car did I mean? Okay, cool. What car do you mean? And if it's not the same car, can you see that we did not have offer and acceptance? Can you see that? Before things get stupid, I need you to see it in a moment. This is the core of what case. What case comes out in here that stands out? These are one of these cases that they use to traumatize lawyers at cocktail parties.
I'm sorry, can you rephrase that?
Sure. There's a case that gets referenced in this case, which is really what this case is about. This case is not about this case. This case is about a different case. It's about Raffles versus Wickelhaus. What the hell's going on in Raffles versus Wickelhaus?
It's two, they don't have the same ship. They're arguing for delivery of shipment of cotton.
Right. Yep. This is the delivery of shipment of cotton to England, and the idea is that, like the cars, what was the argument of the case in Raffles versus Wickelhaus? There was no contract, they said. Because there was no meeting of the minds. That is, party 1 meant, yeah, and party 2 meant the other peerless. That's the black letter law. I need you to see it. Everybody see it before I blow it up? Everybody see it? Cool. Raffles versus Wickelhaus. Do you happen to notice what jurisdiction this was in? Yeah, it was in England. Okay, hang on a second. You guys watch sci-fi, right? Cool. Enterprise, say anything to you? Cool. Which one? D, right? I mean, for life. Absolutely. NCC 1701D, but there's, of course, a bunch of others. The Tragedy of the Sea, right, if you've watched all through there. Starfleet always has an Enterprise. How many peerlesses do you think there were?
Well, there were at least 2.
Yeah, at least 2. Let me get this straight. Who's running this again? Who lost track? And we're supposed to understand that they didn't know what ship was what, that one ship was going where. Which polity was this? Which polity? What country? Not just England, this was. And now I'm getting into thin ice. Somebody said it. The British Empire. You're telling me the British Empire, one, is so unaware of the fact that multiple ships, they have registries. They have registries of registries. They don't lose track of ships. Are you kidding me? This is their whole thing. Their whole deal is ships. Most of them named Peerless. Why did somebody want out of this shipment of cotton? The price changed radically. Why? Because there was a civil war. Where? And which impacted, of course, you got it, right? That's what's going on. One party wanted out of a deal they knew damn well. They knew damn well which peerless was which peerless. They manufactured this uncertainty in order to get out of this because of massive price variations due to conflict in a completely different part of the world. And so even Raffles versus Wickelhaus turns out to be a really crappy interpretation of this. And they get worse. There's another case in which somebody basically tries to buy a cow, and the cow turns out to be they pay a price for it as if the cow can't have calves. And then the cow actually has a calf. And the seller was like, we weren't thinking about the same cow. Because you were thinking about a cow that couldn't have calves. I was thinking about a cow that couldn't have calves. You were thinking about a cow that could, and so it wasn't the same cow. The court fell for it, but do you? Do you see how this whole meeting of the minds thing starts to be bullshit? And why the court can't actually apply the rule of Raffles versus Wickelhaus or restatement section 20, even because it can't be a mind reader. It's exactly what you said. It can't read their minds, and so it's not going to apply this rule, and we generally don't. I'm here to tell you that when I went through contract law, it was offer, acceptance, consideration, and meeting of the minds. Meeting of the minds got taken largely out, not because it is a problem. It is. It's a huge problem. But it becomes a question of a problem of interpretation of meaning, not a problem of formation of the contract. The parties in Peerless clearly intended for there to be a contract, and they probably knew damn well which Peerless was which Peerless. In the cow case, it's pretty clear that the parties were reducing the price of the cow based on the obvious percentage chance that the cow couldn't have thing, and it was put into the price. The uncertainty was already negotiated as part of the price. We're not letting people out of this. So here's what I'm here to tell you that the court in Colfax is not applying the Raffles versus Wickelhaus rule. It can't. If it did, if we took Raffles versus Wickelhaus seriously, there would be no such thing as contracts because none of us have the same subjective interpretations of contractual words. And if you required them to match up, we would never have a contract. All right. Yeah.
So, as far as us not learning that anymore and how you learn that, like, what happened? Like, was there like a hard line that was, or is it still kind of?
It's just kind of faded where courts, what they do is they turn to, what's our saving grace here? If you can't, right? The court can't read people's minds. What's the court going to say to solve that problem? Arbitration, but then the arbitrator can't read people's minds. What's the arbitrator going to do? Send it back to the court. They'll look at what other people do. They'll look at the words as used by the industry. Absolutely. By the way, want to guess in the UCC versus the common law, which one does that far more? Who does it? UCC does it so much more, right? Because they're doing quick, dirty, fast contracts that have lots of terms left out. What are they going to do? They'll supply all those terms from the custom and practices of the industry, right? That's their big, huge fix to all of this. So that all changed. But no, what's the big move? Take the reasonable interpretation of the outward expression of the parties. The objective meaning of the words, meaning drawn from how other people use them, right? The objective meaning of the words as outwardly expressed. This is why courts are writing edits. The meeting of the minds is a real theoretical problem. How can you say that we had offer and acceptance if we truly meant something completely different? But it's a theoretical problem, and what courts will do is they will stop saying there was a contract or there wasn't a contract, and rather they will say, no, looks to me like one or both of y'all screwed up, and I'm going to look for who's at fault. And then it's going to land on that person. Who's at fault in this case? Because? Yeah, because they knew about the ambiguity, and they chose to let it slide. Which means if the court had gone with 60 inches and up, they win. If the court goes down, right, they're not going to go down, right? They're saying this ambiguity could resolve in our direction, and if not, at worst, it's what we negotiated, right? So it's all heads I win, tails you lose. It's all on the upside. And the court said, you were the one who had the opportunity to ask for clarification. You're the one that chose not to do it, which is the actual rule of Colfax. It does not use the Raffles versus Wickelhaus rule because you can't use the Raffles versus Wickelhaus rule because courts can't read minds.
So would you say that they've kind of moved like the meeting of the minds from the formation to like interpretation?
Exactly. 1 1,000%. My best friend says I sound like an idiot when I say 1,000%. I'm sorry, but like I need to express my enthusiasm without swearing. 1,000%, absolutely right. That's precisely what they did. They moved it also not only into interpretation, which is in the 200s, 201 and 221, but they then moved it into defenses, where you start saying, one party made a mistake. Should I let the parties out because somebody screwed up? There was a typographical error, or somebody else made a mistake. You'll see the same analysis again, but what they did was they moved it off of contract formation and into interpretation and defenses. That's exactly right. All right? Great questions. Y'all are killing it. Okay, anything else on this? It's supposed to be about Restatement 20. It turns out to be about why we don't use Restatement 20. But you should be aware of it, and you'll see, by the way, one of my issue spotters on one of the prior exams, go find it. Who knows if I may reuse it? It's one of my favorite ones. Actually just walks you through misunderstanding, mistake, and misinterpretation. And you're just supposed to make every argument. You go through the Restatement 20, you go through the ones in the 50s on mutual and unilateral mistake, and then you go, there's two kinds of mistake. Both people screwed up, one person screwed up. By the way, you want to guess what the rule is if one person screws up? It's called, that's you problem. See Colfax, right? It's the same rule, same interpretation, but displaced over to defenses, where you're making the defense saying, I screwed up. This wasn't what I intended. And the court's generally going to be like, okay, but if the other party relied on it, you're done. Okay, cool. Cool. I think that's going to carry us through then, and then in our last couple of minutes, we will turn to Kat and do Ardente versus Haran. So if you wouldn't mind setting that up for me, please, Kat. Sorry, my glasses aren't on here. 133.
So here the plaintiff Ardente agreed to buy a mobile home park from the defendant for $250,000 in 1975. The plaintiff executed the purchase agreement and submitted a $20,000 check and a letter asking that certain parts replace both items remain on the property. That was submitted by, I think, the plaintiff's attorney. The defendant refused to agree to leave those items as part of the sale, and they moved the term of the sale was at returning the money that they've been provided. The plaintiff then moved for specific performance.
Okay. What's the result of the case?
Well, the defendant moved for summary judgment on the grounds that there was no contract, which was granted in favor of the defendant, as the judge found plaintiff's letters to be a conditional acceptance, which is a counteroffer, which means there was no necessary.
I mean, you're just burning through it, and you're absolutely right on everything, right? It's the same damn deal. What's the key language here in the case that the court's just like, yeah, no, this is what sank you? What did they say? Just here on page 133.
What did you say?
This is plaintiff's attorney.
So
at the bottom of the page 133.
Yeah, like my clients are concerned that the following items remain with the real estate, as they would be difficult to replace.
Yeah, okay, so how is this phrased? Can you save this? What happened in the case? Let's just get through the easy stuff. What happened in the case? What's the end result here?
The court said this was never a contract.
Yeah, there's never a contract, and you've already said why, but let's make it explicit. Why was there never a contract? Yeah, because a counteroffer does not constitute a contract. In a sense, this is just Davis versus, like down to the fighting about mobile homes, right? This is just Davis versus Satcham again. But there is one difference here. That language, is that language a rejection and counteroffer on the bottom of 133?
Well, so the plaintiff says that it's not. The plaintiff says, no, this was like, we agreed to the terms of your contract, we just submitted a request.
Right. Whoa, that's quite a saving legal argument. What would that do? Does that work?
No.
Can you make it work? If you were their attorney, if you were their attorney, right? So you know this, you've nailed this whole theory, right? You know this law cold. You're going to go in. What would you do if you were plaintiff's attorney and you knew your client wants the deal, they just need some clarification?
The judge said that, like, they could have made this work if the attorney had explicitly accepted the terms of the contract and said, okay, like, we accept your contract as it is. As an aside, however, Like, could you also leave these things, maybe these things?
Yeah, exactly. By the way, would that work? Yeah. Now we're getting into the brass tacks of practical lawyering. Any further steps you'd take to like nail that? You're doing everything right. Any further steps you'd take to nail this down where where to make it clear? This is, yes, we're making this request. How would you clarify? So, because you see the risk, right? Like the risk is what they put here at the bottom of 133. That's not expressly a rejection and counteroffer, right?
They had said, we'll accept it anyway. We'll accept that we're accepting the offer, and even if you don't need these things, this contract is still accepted.
Yeah, so that's great. Like you nail that one down. What do you do with the request? Send it separately. I mean, like at some point you want the most separation possible. Well, you want the most separation possible between the two in order to get this effect that Kat's talking about. Does everybody see that a request sent separately from an acceptance would function as an acceptance? The contract is now locked in. We have a contract. And then, hey, would you mind leaving some of this stuff behind? Okay. Again, I think we've got, and we're going to have a couple minutes here at the end of class. I can't believe we've gotten through so much of this stuff. But again, what we see here is the risk of asking for more without being clear as to what you want. They lost the deal that they clearly wanted because they were making these clarification requests, which is also, I mean, we're back to your problem, right? Because what if you were negotiating a deal and you became aware that it wasn't clear? Right? We did this when I sold my house in Indiana to move to W&L. I used to teach at Indiana University Bloomington. Sold my house. There was a porch swing and a bell. And it turns out the porch swing and the bell had been like largely what I was into the house for. That both of them were birthday gifts from my wife to me. And the question was, we got this sort of after the fact. The other party said, well, do I get this or not? There's some fundamental uncertainty. I mean, might as well ask. Anybody here ever live in Germany? Cool. Ever rent a new apartment there?
Yeah.
Okay. Tell me about the floor and the utilities.
It's ridiculous. Yeah.
Not only when you come into that new apartment for the first time do you not have the utilities. You don't have any. Like literally, they take the flooring with them. That is not considered to be part of the apartment. Now that's just cultural, right? But you can imagine then asking for confirmation. What do you think, by the way, the rule is for the rule of just guessing whether or not something comes with a house or not?
If it's attached to the land.
There it is. If it's attached to the land, it's the same rule called fixtures, right? This is the same rule that we use for dividing between common law and the UCC. If the bell were separately, it wasn't. It was attached to the post. If the bell were separate, then it would be UCC. We would negotiate for it separately. But you can see why it's not insane to ask for clarification here. If you want to ask for clarification without losing the deal that you've already got, you do it this way. If you're asking for clarification, though, you could also say, back with Judge Cardozo, if this is an important point to negotiate, maybe y'all haven't negotiated far enough to actually have a deal yet. And that's the cases that we're going to see next time. We'll stop it here a little bit early. That's what we're going to see next time. We're going to stretch out that negotiation period, and we're going to take a long, deep plunge into why offer acceptance and consideration is maybe the worst possible way of describing what actually goes on when businesses are trying to buy and sell businesses. Yeah, yeah, go for it. Yeah. Yeah.
While I was reading this case, it was easier to read because we already read the first case.
Yep.
I have a hard time distinguishing why they're both included in such a short chapter.
Good question. I've routinely thought about killing off Davis. About Ardente. The one thing I can see is this request and separation rule to give you a sense as to how to do it. Because Davis was clearly a rejection and counteroffer. This was not clearly that. It looked like they were just asking for clarification, but they still wanted the deal. And so you needed to see the risks of requesting clarification. And then what I really needed was your work, and you did an excellent job on it, on how to arrange that so you don't get nailed if that's what you want to do. You want to accept it and make a request. All right, thanks, folks. We'll pick this up next time.